Drink the water, drink it down. This time I know I'm bound to spit it back up. I didn't want this salty substitute. It's just not going to do. I need some air if I'm going to live through this experience. Reminds me of a clock that just won't tick. I wanna wake up from this concussion, but my dream is just not done. I'm a little kid. It's just one of those bad days. Look outside and be careful what you ride. You just might find that you're out of time to swim ashore. If I trip long enough, I'll be home.
Please be seated. Welcome to Maastricht University for the inaugural lecture of Professor Anke Moerland. It's great to see you despite this weather. A special welcome to Cornelia and Sigmund Darendorf, the parents of Professor Moerland, to Elisabeth and Henk Moerland, her parents-in-law, to Roland Moerland, her husband, and to Floris and Isabel, her son and daughter. My name is Ronald Janssen. I'm Dean of the Faculty of Law and now acting as Pro-Rector. This is a historic day. It's probably the hottest day an inaugural lecture was ever held at this university, and you were there. But I'm sure it's worth it, for we are going to listen to an exceptionally talented colleague. Professor Moerland, born Darendorf, studied international relations at the Technical University in Dresden before coming to Maastricht University, where she did a master in international and European law, cum laude. She became a PhD candidate and wrote a thesis on the protection of intellectual property in bilateral trade agreements of the EU under the supervision of Professors Anselm Kamperman, Professor van den Bosse, and Professor de Lièvre. She defended her thesis in 2013, and it had a fascinating title, Why Jamaica Wants to Protect Champagne, Intellectual Property Protection in EU Bilateral Trade Agreements. It was nominated for the Stein-Rocken Prize. Meanwhile, Professor Moerland studied Dutch law and obtained her degree, again cum laude. Professor Moerland then briefly worked as an attorney at the German desk of Poul Sanders Advocaten in Venlo, before returning to our faculty as an assistant professor in intellectual property law. She enjoyed legal practice, but came to the conclusion that academia is her true destination. Then things went very fast. Professor Moerland published a number of well-received papers, taught several courses in both the Bachelor and Master program and the Advanced Master Intellectual Property and Knowledge Management, and took up responsibilities in the faculty. She coordinated the APAN Innovation Society, a 4-year project financed by the EU, and the PhD program and Master's Honours track of the Graduate School. In 2023, she became the Vice Dean of Research of the Faculty of Law, and she is a very great Vice Dean of Research. By then, she was already Associate Professor, and in 2025, she was appointed as Professor of Intellectual Property, Frontier Technologies, and International Trade. Professor Moerland is not only well respected within this faculty and in the field of intellectual property law, she is also well liked by all staff, academic and support. She is cheerful and optimistic, she is witty, she has a sharp mind and critical mind, She has a strong sense of justice and speaks out for people in vulnerable positions. She is deeply committed to our faculty. Our community is much more to her than just a working environment, and she is much more to our people in our community than just a colleague. So it is with great pleasure and with excitement that I invite Professor Moerland to deliver her inaugural lecture on academic output as input for AI, what role to play for universities.
Dear Pro-Rector, students, friends, family, and colleagues, also online. AI is being built on the largest unregulated extraction of knowledge in history. Human authors should be compensated for the parasitic usurpation of the market in literary and artistic production. Creators and AI developers have a profound shared interest in ensuring that Europe does not cede ground, culturally, technologically, or strategically, in an era that will be defined by how societies choose to govern the tools of intelligence. These statements by the digital commons community, scholars, and the CEO of a French AI company give an impression of how fierce the debate is around the training of AI algorithms on the basis of millions of creative works without authorization from their creators. All of us, I guess, have read about outcries among several creative communities in the media, but also in courtrooms. Journalists, musicians, scriptwriters, actors, authors, and other creators have filed several lawsuits against important AI companies like OpenAI, Meta, Google, Anthropic, and others. What have academics or university done? Nothing yet, but maybe this will change after this lecture. Today, I would like to use the example of training Gen AI models with copyright-protected works to present in more detail how intellectual property law can serve as a tool to achieve a balance between prevalent societal interests. These are to stimulate innovation in frontier technologies, to reward and preserve human creativity, and to enable society to benefit from high quality and diversity in AI tools. For this, let me first start by explaining briefly the broader scope of this chair. Intellectual property laws are in essence about incentivizing creativity and inventions, both artistic and technical. Intellectual works are public goods. This means one cannot exclude others from using them once they are available, and the use by one does not affect the use by others. A song can be shared and listened to by many people at the same time without excluding or affecting others. As an answer to this, IP rights create exclusive rights through which creators and inventors can control the use of their works. We also speak of a social contract in this regard. Governments provide monopolistic rights so that creators and inventors can make a living. But at the same time, we require them to make their works and inventions available to the benefit of society. Activities like studying protected works and inventions, doing research on them, being inspired by them, and improving them do not fall under IP protection and hence are kept free for all. The goal of IP law can then be summarized as the search for the optimal balance between exclusive protection for creators and inventors and sufficient access to creative works and inventions. The search for this balance, to a certain extent, has sparked my interest from the very beginning of my academic journey. In fact, what I was most interested in when leaving high school was the international system of political, historical, economic, and legal relations between countries, and how these influence the development of countries. At that time, I did not yet realize that intellectual property law plays a crucial role, why certain countries thrive economically and others not. The legal infrastructure to stimulate innovation and creativity through intellectual property law is importantly shaped by national, but also international trade rules. This is particularly so for phenomena that do not stop at the border, like technology. Agreeing on common international principles and standards is hard, particularly in today's geopolitical times. But common rules by which parties are willing to abide have been and hopefully will continue to be the foundations of our international trading system. This will be one focus area of my future research. At this moment, however, we mostly see the quest for the right balance between protection and access to technology-driven creations and inventions unfold at the national level. For example, the EU is exploring and scrutinizing whether its current IP laws are still apt to fulfill their function of stimulating innovation and creation. Because reality is that inventions and creations are more and more created by AI models rather than humans, such as AI-generated computer code, artworks, technical solutions, or press articles. One of the core questions that IP scholarship is already struggling with is whether an AI system or the AI industry need to be incentivized and rewarded for generating creative works or inventions at all. And how would IP law have to adapt to still play a role? These fundamental questions of innovation and creativity in a technology-driven world will have to be answered through interdisciplinary research, to which I intend to contribute with the work carried out under this chair. This inaugural lecture will focus on only one specific aspect that has been debated heavily among IP scholars as well as in courts recently. Does current copyright law allow GenAI developers to use copyright-protected material to train GenAI models without compensating authors? And should this be the case? I intend to answer this question under EU law, both for creative works in general and scientific publications in particular, to then also address the role of universities, that what they can play in this context. I focus my analysis on generative AI models as they are massively rely on creative works, such as pictures, writings, or music as training data. But the issues I discuss are equally relevant for other machine learning models. So why does it matter whether authors are compensated? The core basis of copyright law is to ensure that human authors are stimulated to pursue creative activities and thereby promote the development of arts and sciences. This is achieved through the fundamental right of fair remuneration for authors and performers. In essence, being paid for being creative means that they can make a living out of their creativity. So compensation is needed if we want to stimulate human creativity. There are two further societal developments that require safeguarding remuneration for creators. The first reason is that we need human creativity for cultural and democratic reasons. Humans with eyes, ears, and feelings are a prerequisite for a critical engagement with our society. Producers of movies, music, or drama, as well as journalists and scientists, engage meaningfully with the world around them. By offering their perspectives, they start debates that move society forward. Our democratic system is dependent on this input. A world where it is primarily AI-created ideas that influence our political and societal processes would be poor at least, or a dystopia to others. The second reason is more specifically related to the feeding of AI models with data. Most AI models, like generative AI, constitute machine learning models, which means they need huge quantities of data in order to learn. Such data can be human-created, but also generated by AI, so-called synthetic data. The problem with synthetic data is that overuse thereof will lead to an AI model collapse. A collapse means that the AI model degenerates and hence produces more mistakes, so-called hallucinations, and less diverse output. Therefore, we have a strong self-interest to make sure that human-created works are used to train GenAI models. We equally need to avoid that overly strict EU regulations lead to European works being left outside of training data sets for the next dominant GenAI models. European values and beliefs differ from those in other regions in the world. Output generated by GenAI models should reflect this diversity of values. For these reasons, our copyright rules should incentivize humans to be creative and that their works are used for GenAI training. In order to determine whether under EU copyright law, human creators receive compensation for the use of their works as input for GenAI training, we need to check, first, are the works used copyright protected? Second, whether the exclusive rights, in particular the reproduction right, is breached by the acts involved in training GenAI models. And third, that no exception exists that can justify the breach of copyright. If these three questions are answered in the affirmative, authorization is needed from creators, which is the basis for receiving compensation. Turning to the first question, the law is clear. Any literary or artistic work, including software or databases, can be protected under copyright if they meet the threshold of originality. The Court of Justice of the European Union has held that works are considered original if they amount to the author's own intellectual creation. Facts, information, or data without any intellectual creation are not protected. There is little doubt that academic output, defined as scientific publications, enjoy copyright protection. This means that where researchers make personal choices on how to express and present the analysis of data and information, they will be copyright protected. Where the originality threshold is met, literary and artistic works are protected for an impressive period of 70 years after the death of the author. While the question of copyright protection for academic output is hardly contested, the next step is: does the use of copyright-protected works in the GenAI training process amount to an interference of copyright? Today, we will focus on the reproduction right as the core right under copyright. The EU legislator has given the reproduction right in the Information Society Directive a very broad scope, covering direct or indirect, temporary or permanent reproduction by any means, in any form, in whole or in part. Arguably, virtually any form of reproduction of copyright content is protected. We will now dive a bit deeper into the different stages of GenAI training and assess whether what is being done with the works in GenAI training interferes with this reproduction right. This is important not only to establish that copies have been made and when, but also because GenAI training activities are carried out in different jurisdictions to which EU law may not be applicable. Since many training activities take place outside of the EU, it is particularly relevant whether reproductions are present in the final GenAI model that is offered on the EU market, and hence to which EU law is applicable. While different AI models involve slightly different steps of training, one can simplify the training of GenAI models into roughly 3 initial core development stages. Stage 1 relates to preparing data for training, Stage 2 to training the model, and Stage 3 to the final trained model. The first stage essentially entails the creation of a training data set. which is in many cases comes down to automated scraping of online content. Where data is scraped from the internet, the data inevitably has to be stored and transferred to the operating system for the purpose of conversion. Some form of copies are needed for that. Also, the cleaning and pre-processing of data requires the making of reproductions in order to eliminate wrong and redundant information and to transform it into a machine-readable format. Even where only temporary copies are made, according to existing case law, these fall under the broad right of reproduction right. So, if copyright-protected works become part of training data, copies are likely to be made. The second phase looks at the actual training process of the model. Here, it is more difficult to establish with certainty where and how exactly reproductions take place. From what we know, how machine learning in convolutional layers works is that a model initially has random weights, and by feeding it with training data in multiple training rounds, the weights are adjusted each time to make the model perform better. For the training rounds, reproductions of elements in training datasets are made that enable the model to fine-tune its performance. In the example of diffusion technology, very similar versions of the same images with different levels of noise are fed to the model to learn the different features in the image. What this shows is that even if reproductions are not in human perceivable form, they are made in abstract or statistical form, which is also covered by the reproduction right. The third stage regards the final GenAI model, that is the result of the development process. While AI developers concede that the training process in stage 2 may involve temporary copying, they contest that the final GenAI model contains copies of works on which they were trained. From what we know about the technical workings of GenAI models, the information in its training data shapes the model. When the model is prompted to generate outcomes, it draws information from the internal statistical storage and reconstructs it into human perceivable form. In the recent GEMA versus OpenAI judgment, the Munich Regional Court found that the memorization of considerable fragments of song lyrics in itself was sufficient to find that reproductions of training data remained in the model and hence could be extracted as outputs. It held that the technical details of memorizations are unimportant. What according to the court is decisive for copyright law is that the lyrics of the songs in question could be reproduced in a form that was perceptible for human senses. Whether this judgment will hold an appeal on this point is unclear. Some concerns exist with the approach chosen by this court, as other technical explanations are possible for memorizations that do not necessarily involve reproductions. I will not go into more detail on these technical matters. Instead, I would like to present a new approach that does not rely on reproductions as such being present in the model, but on functional equivalence. This approach would do away with the need to prove reproductions being present in AI models, which is inherently difficult where fast-developing technical realities quickly change the exact technical workings of AI models. According to the functional equivalence approach, scholars suggest that instead of relying on reproductions, we should treat the embedding or ingestion of works by GenAI models as functionally equivalent to the reproduction of these works. Where copyright-protected works are used for GenAI models to learn the information therein, this should be enough to amount to the essence of what the reproduction right is about. As law cannot always foresee which new situations or technology may arise, the concept of functional equivalence offers a solution in treating similar activities in a similar manner as long as the function of the legal rule is fulfilled. The core of the reproduction right is about the storage of protected content in whatever format, duration, and for any subsequent reuse purpose. Arguably, this is exactly what happens when ingesting works into a GenAI model. The ideas and expressions contained in the works are encoded and hence stored in digital form in the parameters of the model. Even though we may not be able to identify reproductions in the model, it would be enough that they have been used to create the model. I propose to follow this approach, which would require courts to go beyond the interpretation of the reproduction right so far and accept ingesting copyright-protected works into AI models as functionally equivalent to reproduction. In summary, all three phases of GenAI training are likely to entail acts that are covered by the reproduction right: the gathering and preparation of training data in stage 1, the actual training process of stage 2, and the final model in stage 3. The next question that arises is whether there are any exceptions in copyright law that apply to the training of GenAI algorithms. If, in the broader balance of interests of all stakeholders involved, other interests weigh stronger than the protection of copyright, we usually create an exception that justifies the use of protected works for certain purposes. These exceptions are limited to certain special cases and take into account the legitimate interests of right holders as well as broader societal interests. One such exception is for temporary copies. Accordingly, transient copies made during GenAI training, in particular in stages 1 and 2, are allowed under copyright law. But copies that are, for example, not automatically deleted after the completion of pre-processing acts, and certainly the functional equivalents ingested in the final GenAI model, do not benefit from this temporary copying exception. This brings us to another important exception. The so-called TDM exception allows AI developers to carry out text and data mining, even for commercial purposes. Text and data mining is defined as the automated analytical technique that analyzes text and data in order to disclose new trends, knowledge, and information. According to the rationale of this exception, there is no obvious conflict with the rights of authors to exploit their works because TDM is limited to mere automated data analysis, such as extracting, comparing, classifying, or otherwise statistically analyzing large number of works. Looking at the AI training stages, it is relatively certain that the activities taking place in stage 1 and 2 fall under this definition, as confirmed by recent court decisions. This is different if we look at the third training stage. The functional equivalents ingested in the GenAI model are not used for mere data analysis or to disclose new information. To the contrary, the trained GenAI model is used to generate similar to or derivative content from human creations. The consequence is that the TDM exception does not apply to stage 3. But also for stages 1 and 2, there is another complication. Right holders can declare they do not want AI developers to carry out TDM activities in relation to their works. They can opt out from the exception. While the hope was that this opt-out would incentivize the creative and AI industries to agree on easy-to-use technical standards to actually reserve the rights, this has not materialized, which I will develop later in the next part. For now, this concludes the analysis of the law as it stands. It suggests that reproductions or equivalents are likely to exist in all stages of GenAI training. Only some of these reproductions, particularly in stages 1 and 2, can be justified through existing exceptions. For those, AI developers do not need authorization to train GenAI models and hence do not have to pay remuneration. On the other hand, for equivalence ingested in the trained GenAI model, no valid exception exists. This means that such reproductions of copyright works need to be authorized by creators, who in turn can generate compensation for such use. Now, let's turn to the question whether the analysis of the current law can be qualified as achieving the objective stated above. Does it foster the development of high-quality, diverse GenAI models that also reflect European values, while sufficiently incentivizing human creativity through remuneration? The answer currently, I think, is no. Let me briefly explain the problems and suggest the direction in which I want to develop my research further. First, the TDM exception should be reformed to eliminate the opt-out for authors. Instead, what should be added is a remuneration requirement for any commercial use made for TDM purposes. In my view, while the purpose of the opt-out was exactly meant to create opportunities for remuneration, the technical process of declaring one's reservation of rights, either individually or through collective society, unnecessarily complicates the matter. For AI developers, it requires extensive efforts to determine which right holders have validly declared the opt-out at which moment in time, in order to then ensure that such material is not part of their training data set. This situation does not foster the use of European copyright materials for GenAI training, nor does it provide fair remuneration to authors. Instead, an encompassing remuneration requirement should be added to the TDM exception. All right holders would be entitled to compensation when their materials are used for GenAI training. I would establish a statutory It would establish a statutory requirement of remuneration for the activity of text and data mining for all copyright works, which currently is absent. This solution also provides more legal certainty for commercial AI developers, who generally would need to obtain licenses for TDM purposes. While this may increase AI developers' expenditures, the clear advantage for them would be that all TDM activities are allowed in the first place. AI developers also face less regulatory hurdles, and they thereby are more likely to include instead of excluding EU copyright materials in the training sets of their GenAI models. But also beyond the TDM exception, fair remuneration for human authors is similarly required for functional equivalence ingested in GenAI models to which the TDM exception does not apply. At this moment, there are only few AI providers who have obtained licenses and hence pay remuneration for the use of copyright materials to train their GenAI models. Partly, this can be explained by a certain degree of legal uncertainty around the question of infringement and other external factors, but it undoubtedly is also due to the fact that AI companies shamelessly make use of the regulatory vacuum we currently have. This situation has led to a call to introduce new mechanisms that can achieve remuneration. There are several options on how compensation for authors could be organized, including voluntary licensing, extended collective licensing, and mandatory remuneration. My preference lies with a mandatory levy at the output stage, suggested by Martin Senftleben. Such a levy is not unknown to copyright law, as we have a similar system for making private copies, for example, CDs. Some of us may remember buying empty CDs and paying a private copy levy for that. The levy proposed for GenAI models would have to be paid when offered on the EU market, and its amount should be proportionate to the revenue incurred. The generated remuneration would then be redistributed among European collective societies, whose task should be to build social and cultural funds that can support human creators as a way to continue supporting human creativity. it is clear that my work and that of others will continue to discuss the benefits and concerns that this and other solutions offer before a solution is found and implemented on the market. This prompts me to now address the role of universities, the last part of this lecture. Universities have a clear public interest mission. It is to disseminate research results to the benefit of society. To me, this means that universities should promote the use of academic output as input for AI. As argued above, it is in society's best interest to have works from European authors included in GenAI training sets, as it ensures high quality and diverse AI output that reflects also European values. Academic publications are the result of sound scientific research. We have an obligation to make this information available, and to my mind, this includes through dominant GenAI models. This premise should be made explicit in universities' AI policy. At the same time, certain safeguards should be preserved. One such safeguard relates to ensuring remuneration for human researchers. The other safeguard concerns respect for research integrity principles in relation to AI training. I will address both in turn. The way to ensure appropriate and proportionate remuneration is through including such a requirement in the terms of licenses that researchers attach to their publications. These licenses differ depending on the various forms of publishing applicable in the academic field. One form of publishing is with commercial publishers, like scientific journals or book publishing houses. Another form of publishing is open access publications, which can be concluded with commercial publishers, but also commonly shared through university repositories or presses. When it comes to the publication of articles in journals or chapters in books with commercial publishing houses, researchers usually transfer their economic rights held in the work to the publishers. Without any specific provision in the contract on how publishers can exploit the works, for example, for GenAI training by themselves or by third parties, it is the publisher who determines under which conditions the content is used, including for GenAI training. Here, I foresee a twofold role for universities. First, together with other universities and research organizations, they should develop a common position of requiring appropriate and proportionate remuneration for the use of scientific publications in GenAI training. Many of us will know from experience that negotiating the terms of these contracts with publishers individually is unlikely to end up with an appropriate and proportionate remuneration. This would only work if universities together managed to put a price tag to the use of academic output for GenAI training. Universities would then also be best placed to raise awareness and support researchers when negotiating the terms of publishing contracts. Second, it seems logical that the remuneration from licensing contracts would not accrue to individual academic authors, but to universities that would be tasked to build funds with the aim to support the development of human scientific talent. In this regard, the aim of a remuneration clause in licenses would not be meant to pay researchers who often already have an income, but to ensure that where academic output is used to train future AI researchers, universities start mitigating the disruptive effects that this may have on human researchers by funding dedicated projects. The same question of requiring appropriate and proportionate remuneration arises in the context of open access research output. In fact, academic output is widely available open access, as the vast majority of universities adheres to open science principles. The Dutch Copyright Act even guarantees green open access for all short scientific works 6 months after their publication. It is then not surprising that materials available, open access, are massively used to train AI models, because open materials do not require remuneration. Most open access academic content is published under the Creative Commons BY license, which is the most open license. It provides a free of charge license to distribute, remix, adapt, and build upon the material, including for commercial purposes, as long as attribution to the author is guaranteed. It is obvious that requiring remuneration for researchers under a Creative Commons license seems to be at odds with open science principles and the fundamental premise of sharing research output free of cost as widely as possible. However, we see discussions arising in the Creative Commons community that ask whether some form of remuneration may be in order, may it be in the form of a monetary or in-kind support of the creators who share openly, or to the ecosystem and ecosystem that they are benefiting from. This call stems from a fear that creators and institutions will stop sharing materials openly if private and closed AI systems treat open access content as a reservoir of raw materials and do not share the output openly themselves. Until then, however, open access publications are not suited to provide remuneration for academic authors. Leaving the remuneration for human researchers aside, there is yet another safeguard that universities should pay attention to, both for commercially published and open access academic output. That is the respect for fundamental research integrity principles, in particular, the requirement of attribution. Referring to the author of a work, in fact, is protected as a moral right of the author. Equally, the attribution requirement is the one common feature of all Creative Commons licenses, and therefore a key requirement of open access publishing. Yet, attribution is hardly respected when data is used to train AI models, unless citation capabilities are offered in the GenAI tool. The European AI Act does require transparency about training data. However, it does not encompass an obligation to provide lists of copyright works ingested in the model. I suggest that universities stress the importance of attributing academic authors when their works are used for GenAI training. This means that GenAI tools with strong citation capabilities should be preferred over those that don't. This could even be reflected in publishing contracts concluded with commercial publishers, which can contain the condition that the use of their works for GenAI training is limited to the development of GenAI tools that enable attribution. A requirement of attributing authors would also serve our academic research system in general. The correct allocation of sources is an important form of ensuring verifiability of research results. Where information presented by GenAI models is not retrievable to the original source, research results risk being decontextualized. Hidden or misattributed sources prevent others from verifying information, which endangers the reconstruction of intellectual lines of thought. This is particularly disruptive for interdisciplinary research, which is likely to be innovative and hence not easily traceable combinations of theories, methods, and insights from different disciplines. Furthermore, the recognition of one's work by peer creators is an important driver of creativity. This is certainly true for academics as well, who are not only intrinsically motivated to contribute to the state of the art, but for whom peer recognition is an important extrinsic driver to publish relevant research. Where others engage with your work, it is a sign of high quality, it can advance your career development, and it stimulates further research. The development of AI models with citation capability poses dangers to these incentive structures, which our research system relies upon. For all these different reasons, universities have a clear interest in fostering the development of GenAI models with strong citation capabilities, which will enable attribution of authors, the verification of research results, and consequently its wide dissemination. Let me conclude. It is a challenging exercise to devise copyright law in such a way that the development of GenAI models is fostered, human creators are remunerated, and European values and beliefs are included in these models. I've outlined briefly that current copyright law requires remuneration for human authors when using their works as input for GenAI training. At least for the final trained model, currently no exceptions apply that would allow AI companies to evade authorization. But also for the TDM exception, I've argued that the inclusion of a remuneration requirement would be favorable. The way remuneration can be collected is still subject to discussions. An AI output levy for any GenAI model offered on the EU market currently seems to be the most promising solution. But even if in the EU we find an appropriate way to regulate technology-driven innovation without marginalizing human creations, it will depend on how internationally we can agree on general values that different countries share. Because what we already see is that there is competition among countries to offer particularly permissive rules for AI companies to invest in those jurisdictions, and then a stricter region like the EU may lose out overall. My conclusions for universities follow this analysis. As public interest organizations, universities have a task to foster the wide dissemination of research. Hence, they should promote the use of academic output as input for GenAI as part of their policy, albeit with respect to certain safeguards. I argue that collectively, universities and research institutions should support researchers to ask publishers to pay appropriate and proportionate remuneration for the use of academic publications as input for GenAI training. This revenue would enable building funds that are meant to support the development of scientific talent. And finally, universities have an urgent task of emphasizing the need for attributing the works that have been used in GenAI training. This concludes the academic part of this lecture. But we are not done yet. There's more to be said, not about IP law, but words of gratitude. I'm very grateful to stand here today. I'm grateful because I know it is not only my hard work, dedication, and a good portion of luck that brought me here. It is also because many people along the way have supported me by offering me fantastic opportunities, functioning as role models, challenging me and my beliefs, offering an open ear, a shoulder to cry on, and very importantly, moments of laughter and joy. And it is now time to thank them for that. Let me start with a big thank you to those that have agreed to grant me this chair, in particular the Appointment Advisory Committee, the Executive Board of Maastricht University, and the faculty board members, including the former Dean of the Law Faculty, Jan Smits. Establishing a chair that puts the role of intellectual property for upcoming technology at center stage is not an obvious choice, but it is a great honor that I will be able to fulfill this role, and I'm very thankful for the opportunity granted to me. Jan, I know that you are watching online, and therefore I would also like to take this opportunity to thank you for the trust you have put in me. It was a big surprise when you asked me to join the faculty board in 2023, because we hardly knew each other. Even a bigger surprise was the realization that we actually got along really well. I've learned a lot from you, both as a researcher, leader, and person. Dankjewel. Much longer ago, during my master's studies at this faculty, there was another surprise. I signed up for a summer school in Macau because Peter van den Bosse was teaching international trade law there. But part of the deal of participating in the course was to also take another 2 weeks of summer school in intellectual property law with Anselm Kamperman-Sanders and Christopher Heath. It turned out that these 2 weeks changed my further studies to become the topic of my PhD research. I owe a lot to Anselm and Peter for giving me the chance to explore my academic endeavors in this, to me at the time, still relatively unknown area of law. To Anselm, I'm very grateful that you have found money to offer me a job after my PhD trajectory and intermezzo at Boel Sanders Advocate, and since then for having been an incredible mentor and colleague for so many years. There are more members of our IPKM and EAGER team that make teaching, running projects, organizing conferences, conducting research, and traveling a lot of fun. Dick, Mihir, Christopher, Kalpana, Gabriele, Niels, Dominic, Andre, Belen, Iveta, Denise, and so many more. This is how teamwork and team science should work. Another team is team research, with Diana, Mario, Maxime, Sylvia, Michael, Claudia, and of course, Lisette and Patrick. We work closely together, share good and difficult moments. What I appreciate enormously is that what drives all of us is to help our researchers in doing what they are good at. Even though they can be very difficult clients sometimes, we always find a way, sometimes with a tear, but very often with a smile. This is also the case for the group of highly talented colleagues in the graduate school. Julia, Elvira, Andre, Daniel, Michele, Nikki, Georgia, and again, Lisette. Our common goal is to build a community for our PhD researchers in which they can learn, feel safe to make mistakes, grow as academics, and find their way. I'm very proud being member of that team. Let's not forget about the faculty board. You may not believe that steering the faculty through happy and challenging moments can be a lot of fun. And that is due to the members of the board. Floortje, Mariah, Heidi, Short, Mark, Ronald, and Brahim. You are a really great team to work with. And that is not only due to Floortje and Mariah's nabesprekingen over some very pleasant drinks. I'm running out of time and there's many more people to thank. Silvia, Nina, Laura, Nani, Eliza, Jennifer, and Marco. My time as a bachelor, master, and PhD student would not have been the same without you. We supported each other where needed, and we continue to do so. Having friends all over Europe is a challenge, but what is most remarkable is that when we see each other again, it is as if not much time has passed since the last time we spoke. Silvia, du hast schon immer eine ganz besondere Rolle in meinem Leben gespielt und ich bin super happy, dass das noch immer zo is. Elke, Martijn, Gaston en Mariska, jullie hebben zonder enige aarzeling jullie huis voor me opengezet toen ik in 2006 verkering met Roland kreeg. Het was een enorm cadeau om zo warm in jullie commune opgenomen te worden. Ik heb je heel veel aan gehad en daarna niet alleen mijn Nederlandse taalkennis. Es geht weiter mit den wichtigsten Personen, meiner Familie. Liebe Mama und Papa, euch gebührt ohne Zweifel mein größter Dank. Dafür, dass ihr mir eigentlich alles ermöglicht habt, was ich wollte. Von Sprachreisen über Nachmittagsveranstaltungen, Studium, Gespräche über Politik und dass ich mir ohne Schuldgefühle ein Leben etwas weiter weg von euch, als ihr vielleicht wolltet, aufbauen konnte. Es ist ein großes Vorrecht, in so einem Zuhause groß geworden zu sein. Ich denke, eure Anstrengungen haben sich auf jeden Fall gelohnt, auch wenn, lieber Papa, der Professortitel noch nicht vor dem 40. Geburtstag kam. Der heutige Tag ist auch euer Tag. Bedingungslose Unterstützung habe ich auch von dir, lieber Ina, erfahren. Seit meinem ersten Tag in dieser Welt hast du auf mich aufgepasst. Und immer noch bist du für mich da, wenn ich es brauche. Gerade weil wir so unterschiedlich sind, helfen mir deine Sichtweisen und warmen Worte enorm. Vielen Dank dafür. En nu nog naar het andere deel van mijn familie, hier in het mooie Limburg. Betsy en Henk. Veel mensen vragen hoe het is om met mijn schoonouders samen te wonen. En ik kan er kort over zijn. Het is gewoon erg mooi om met elkaar te genieten van een geweldig huis, tuin, huisdieren en natuurlijk van elkaar. We zijn er voor elkaar waar nodig en we hebben ook nog plezier met elkaar. Wat een luxe. Floris, Isabel en Roland. Jullie maken regelmatig grapjes erover wat voor mij het belangrijkste is. Het werk, onze hond Vesper of de robotstofzuiger. En ja, onze hond gebeurt veel dank voor de mooie wandelingen. Misschien lijkt het er niet op, maar in mijn hart staan jullie op nummer 1. Isabel en Floris, het is geweldig jullie te zien opgroeien. Het leven is zoveel leuker met jullie. Roland, ik mag van jou niet te veel zeggen, maar ik kan dit moment niet voorbij laten gaan zonder jou specifiek te danken. Voor de steun die je op jouw manier iedere dag aan mij geeft. Het is zo bijzonder dat wij deze weg als academici vanaf het begin samen hebben bewandeld. Maar nog belangrijker is dat jij samen met opa voor ons niet alleen een huis, maar een thuis hebt gebouwd. En dat is waar ik na mijn werk elke dag heel graag naar terugkom. Ik heb gezegd.
Thank you, Professor Moerland, Anke, for this inaugural lecture. It's timely, urgent, clever, engaging, just as we expected, and I'm sure that it will help the upper floor of this building, where the executive board is, to help think about the future of Maastricht University's policies in AI. We're so happy that you've now joined officially the professorial rank of the Faculty of Law at Maastricht University. And congratulations to Professor Kamperman, your thesis supervisor, and the head of the Department of International Law. Congratulations to your parents-in-law, and to Roland, of course. And to Floris en Isabel. Jullie hebben echt een fantastische moeder, hartstikke slim, heel erg aardig. We zijn ongelooflijk blij met haar. En het is echt een prachtige dag, ook voor jullie. With that, we come to the end of this ceremony, and I'm going to advise you something which you're not going to heed. That's always the same thing. What I'm going to advise you is not to stand in line or form a queue and congratulate Professor Moerland, Anke, but just take drinks, talk to each other about this fantastic lecture, about this wonderful and special day, and then find a moment to congratulate her. Please do it in that way. But of course, you can also stand in line if you really wish. And with that, I'd like to conclude this ceremony and invite you to go to the rectory. Okay, bye-bye.